We will be welcoming our dignitaries soon. So I request all of you to kindly be seated and switch off your mobile phones, please. We now have the privilege of welcoming our keynote speaker and our honorable judges to the conference hall. We extend a very warm and respectful welcome to the honorable judges and the dignitaries as they kindly take their seats. We sincerely thank our esteemed dignitaries and all of you for graciously sparing your valuable time to be with us and for honoring this program with your presence. I would request the House to settle down, please. Mr. V. Sudhish Pai, the keynote speaker of this workshop, Honorable Mr. Justice Shobhashachi Bhattacharya, Judge, High Court at Calcutta, and Honorable Member, Committee for West Bengal Judicial Academy, Honorable Justice Shampa Sarkar, Judge, High Court at Calcutta, and Honorable Member, Committee for West Bengal Judicial Academy, Honorable Mr. Justice Joy Shen Gupta, Judge, High Court at Calcutta, and Honorable Member, Committee for West Bengal Judicial Academy, Honorable Mr. Justice Tirthankar Ghosh, Judge, High Court at Calcutta, and Honorable Member, Committee for West Bengal Judicial Academy, Honorable Mr. Justice Krishna Rao, Judge, High Court at Calcutta, Honorable Mr. Justice Ajay Kumar Gupta, Judge, High Court at Calcutta, Learned Chief Judges, City Sessions Court, City Civil Court, and Presidency Small Causes Court, Learned District Judge of the South 24 Parganas, Learned Principal Secretary, Law Department, Government of West Bengal, Legal Remembrancer to the Government of West Bengal, other senior district judges of the City Civil Court, Learned Register Inspection, High Court Calcutta, Learned Register Judicial, High Court Calcutta, and other learned members of the Registry of the High Court, other officers posted in the government departments, participant judicial officers from district judgeships of South 24 Parganas, North 24 Parganas, City Civil Court, City Sessions Court, and Presidency Small Causes Court, probationary officers of 2022 batch undergoing training in the academy. Ladies and gentlemen, a very good morning to all of you. On behalf of the West Bengal Judicial Academy, myself being the additional director, extend a very warm and respectful welcome to all of you. We are deeply honored by your gracious presence. Today's gathering invites us to reflect on the enduring values of constitutional governance and the pivotal role of courts in nurturing those values. We are assembled for a training workshop on constitutions, constitutional law, and constitutionalism, courts' role in promoting constitutional culture, and to benefit from the deliberations of our distinguished keynote speaker, Mr. V. Sudhish Pai, an eminent jurist and a constitutional scholar whose scholarship and advocacy have consistently enriched constitutional discourse. We shall now take a moment to felicitate our distinguished dignitaries, a gesture to be carried out by the youngest members of our judicial fraternity. May I now call upon Akash Raut to present the Uttoriyo to our eminent speaker, Mr. V. Sudhish Pai. Kindly put your hands together, audience, for a warm applause. I now call upon Hardika Rajdev to present a potted plant to Mr. Sudhish Pai. May I now call upon Pooja Singh to present a potted plant to the Honorable Mr. Justice Shobhashachi Bhattacharya. We are gracefully honored to have with us today Honorable Justice Shubhra Ghosh, Judge High Court at Calcutta, and Honorable Justice Shaukato Bhattacharya, Judge High Court at Calcutta. I now call upon Kasturi Datto to present a potted plant to Honorable Justice Shampa Sarkar. Rahul Sheikh is called upon next to present a potted plant to Honorable Mr. Justice Joy Sengupta. I will now call upon Ankona Rai to present a potted plant to Honorable Justice Shubhra Ghosh. Next, I call upon Dikila Sherpa to present a potted plant to Honorable Mr. Justice Tirthankar Ghosh. Upama Ganguly will now present a potted plant to Honorable Mr. Justice Shaukato Bhattacharya. I now call upon Neelu Siddiqui to present a potted plant to Honorable Mr. Justice Krishna Rao. May I now call upon Shurjo Shikha Roy to present a potted plant to Honorable Mr. Justice Ajay Kumar Gupta. Thank you, our officers. Before we proceed to the theme of this workshop, it is our privilege to formally open the program with the welcome address. May I respectfully beseech your lordship, Honorable Mr. Justice Shobboshachi Bhattacharya, Judge High Court at Calcutta, to kindly deliver the welcome address. My lord.
I wish all of you a very good morning. Thank you for coming, sacrificing this warm Saturday. The winter is leaving. It's nice and warm outside. So thank you for coming, all of you. I welcome each and every one of you. But as in the WhatsApp acknowledgements to birthday wishes, I wouldn't name singularly people so that I don't miss out anybody. My dear colleagues here, I welcome all of you for coming here from my court, as well as the judicial officers from the district judiciary. Mr. Pai, I'll come to last because he is the cynosure of attention today. So welcome to him also, and each one of you. Now, today we are here to discuss, the topic is before you. The focus will be on the role of courts in promoting constitutional culture and constitutionality, constitutional law, that will be on the backdrop. Constitutional law, as you know, all of you know, the constitution is the grand norm of Indian legal structure. So it's like the sort of cosmic first principle, which is self-effulgent and sheds light on the other laws and also breathes life into the other laws. But the constitution, as the framers of the constitution, the founder parents of the constitution, their intendment was reflected in the very first sentence of the constitution. In fact, because it's we the people who are giving the constitution to ourselves, that reflects the ethos inbuilt in the constitution. But the constitution is not a dead letter as intended by our founder fathers, despite the basic structure doctrine having evolved subsequently. It's a living document. All of you have heard this. Why is it a living document? Because it has to reflect every moment the changing modes of society, the dynamism inbuilt in a society, in a living society, that has to be reflected in the constitution, either by way of constitutional amendments or interpretations of the constitution by the courts, by the Supreme Court, by the different high courts and different other courts. So therefore, it's a living document. It's not a legal document only, as you all of you know. It's a political document. It lays out the federal structure and also the central level and the state level, all the three wings of the governance. I mean, the legislature, executive, and the judiciary, all of them, their roles are laid down in the constitution. It provides a roadmap, it's a blueprint of what our democracy is intended to be. So now these constitutional ethos, what are the constitutional ethos? For that, Mr. Pai is an authority. I'll speak about him last. But uh, from our perspective, I mean, why now we have an impression that constitutional courts means the high courts and the Supreme Court, which they are otherwise because of very important certain features. These are courts of records, and ancillary power of contempt is also there. Judicial review power is there, 226, 227, 32, Article 32. Those are there definitely. But we have to remember the first court of learned civil judge junior division in the smallest district of the country and the first court of the Honorable Supreme Court, the CJI, all of them are creations of the Constitution. Therefore, in that sense, all of us sitting here and listening to this program, they are all constitutional courts. They are the creations of Constitution. And when we dispense with law to the common person, so-called common person, who is a person just like us, while dispensing with the law, we have to keep in mind, we have to imbibe and be imbued by the constitutional ethos and the principles embodied in the Constitution. So therefore, the yardstick, the anvil on which we decide law and interpret law is always the constitutional principle, the constitutional philosophy, which we have to put into the law. So who is better than Mr. Pai to speak on this subject? And we shall have, I'm sure when you leave the room, will be a much better enlightened crowd of people after Mr. Pai speaks. Now, about Mr. Pai, no introduction is required actually, but even then, I have to do the regular thing. I mean, I won't give you a biodata of him because you can always find the life of Pai or the life of Mr. Sudesh Pai in the internet. So, need not elaborate on that. But Mr. Pai is an eminent jurist and a senior advocate, but his identity is not confined to that. He has some widely acclaimed books to his name, and some like Legends in Law was referred to by our Honorable Chief Justice in a program we had day before yesterday. There are other 75 years of the Constitution. He has written several books on eminent personalities. Soli Sorabji, Justice Venkatachalaya. He has got so many books in a YouTube channel called Lex Concilium. It starts with that name. We have, it's on a interview format. In that, Mr. Pai often shares his views also. He is not restricted, confined to being a legal analyst. He is many persons in one. He is a legal philosopher, he's a legal historian, a legal biographer, and a ruthless critic, which we love about him. He does not mince his words. He's a ruthless critic of where the democratic wings don't function properly and where we are failing the Constitution. Yesterday we had the advantage of having him in another program. So there he used something called, there are landmark judgments and landslide judgments. So which I loved actually. So those landslide moments also, he is one person who will tell you that this is wrong and this is not correct on the face of you. So we'd love to hear him on that instead of wasting time further. So I'll be welcoming Mr. Sudesh Pai after a short intro probably. Thank you very much.
Thank you, my lord, for your inspiring words that provide a fitting prelude to the deliberations that will follow. In the meantime, we have amongst us Honorable Mr. Justice Rajshekhar Mantha, and I would request Nilu Siddiqui to please present a potted plant to Honorable Lordship. We shall now move to the central deliberations of the day: constitutions, constitutional law, and constitutionalism, court's role in promoting constitutional culture. With permission from Lordship, I would add a few more words to introduce our eminent speaker, who is a senior advocate, as Lordship mentioned, a distinguished jurist, and an acclaimed author in the fields of constitutional and administrative law. With over 4 decades at the bar, primarily at the Karnataka High Court, Mr. Pai brings a rare blend of rigorous scholarship and courtroom excellence. A postgraduate in mathematics and a graduate in law, Mr. Pai began his professional journey under late Sri S. G. Sundaraswamy, former Advocate General of Karnataka, and later served as government advocate from 1999 to 2006. Beyond advocacy, Mr. Pai's contribution to constitutional scholarship is profound. His writings, often cited by the Supreme Court and various high courts, reflect deep, critical engagement with constitutional interpretation. Mr. Pai has authored several seminal works, including authoritative judicial biographies. Mr. Pai has also assisted Dr. Durgadas Basu in revising the celebrated commentary on the Constitution of India and contributed to Supreme Court projects such as Restatement of Indian Law and Courts of India. Mr. Pai was a visiting chair professor, Ashutosh Mukherjee Chair in the West Bengal National University of Juridical Sciences, and is a serving resource person at the National Judicial Academy, Bhopal. Most recently, through his work on 75 years of the Constitution, Supreme Court's role in promoting constitutionalism, Mr. Pai has eloquently captured the creative and transformative role of the court in shaping constitutional culture. He has also been the recipient of the prestigious Scotch Literature Award for his acclaimed work, The Man and the Judge, a Venkatachalaya reader, a tribute of rare depth and sensitivity to Honorable Justice M. N. Venkatachalaya, which stands as a scholarly homage to one of the most distinguished judicial minds of our constitutional history. Our Constitution is a celebrated charter. We have recently commemorated our 76th Republic Day. Though more than 76 years have passed since its adoption, as Mr. Pai has very aptly remarked in one of his lectures last year, the Constitution is not old, it is 75 years young. And as Lordship mentioned, a living and a vibrant document breathing life through judicial interpretations. With these words, and in eager anticipation of his insights, may I invite Mr. Suvi Sudesh Pai to kindly take the podium. Sir, the floor is now yours. Thank you. You can also sit and listen.
Honorable Judges, the High Court of Calcutta, Honorable Judges participating in this seminar, friends, I'm extremely privileged and thankful for being invited here to be with you this morning and share a few thoughts on a subject which is of deep significance and interest to us, particularly in the field of law, and even otherwise to every responsible citizen. Because as Justice Frankfurter said, in a democracy, the highest office is that of the citizen. And the citizen is the ultimate guardian and torchbearer of the Constitution. And our Constitution itself, as Justice Sabyasachi Bhattacharya reminded us, starts with the beautiful words, we the people. It's ultimately we the people who matter. The aspiration to make power impersonal and its exercise accountable has been the motivation for constitutions and constitutionalism. The advent of democracy and limited government heralded the concept of state and transformed the status of the governed to citizens. Today we are citizens. We are not governed by a Raja or an emperor. We are citizens. And we occupy the highest office. The President of India, who no doubt is the head of the state, is our first servant. We are the masters. Civilization involves the subjection of force to reason. The agency of the subjection is law. Law eludes a precise definition. However, the Brihadaranyaka Upanishad says law is the king of kings, far more powerful than they. By its strength as that of the highest monarch, the weak shall prevail over the strong. So that is law. And it is that which is your instrument as judges to dispense justice, far more powerful than kings. Law embodies a code of conduct and self-discipline, which a nation speaking through its representatives, the legislature, adopts for itself and enforces through the machinery of the judiciary. Law, and even more constitutional law, is the means of ordering the life of a nation and its people and the relations between man and man and the state. Now, law, as we all know, is broadly divided into private law and public law. Private law deals with private rights and obligations. The public law, and constitutional law is a branch of public law, is concerned with the organization and powers of the state in relation to the organs inter se and also between the state and the individual. Constitutional law deals with different organs, their structure, their organization, powers, functions, and relations inter se. It may be broadly described as the whole system of government. And in a in a limited form, it could mean the rules embodied in a document. The Constitution is a document. Men throughout history have longed for a higher standard by which their own man-made laws can be tested. Constitutions are that higher standard. That's why we call the Constitution the grand norm. The belief that individuals have natural rights, inherent and inalienable. The Constitution has not given us any rights. They inhere in us as human beings. These rights are anterior to any written instrument, including a constitution. Government acquires its authority from the people. The purpose of government is to promote the common good. This is what conceives and conceptualizes a constitution made in the name of the people. Defining the powers of the main institutions, delineating the relationship between organs of government and between government and citizens. It is framed for ages to come and designed to approach immortality. So no question of being young or old. Designed to approach immortality, of course, as nearly as human institutions can. Because nothing that is human can ever be immortal. Constitution, as I said, refers to the document, while constitutional law refers to the justiciable parts of the document, those rules which have been evolved by courts in enforcing the justiciable provisions. Equally important, conventions, customs, usages are all part of constitutional law. No constitution is complete. As Professor Lawrence Tribe, perhaps the greatest living authority in American constitutional law, of course, digressing for a moment, someone in a lighter vein said he must be feeling so bad today. We all know the state of the law in the United States. Professor Lawrence Tribe is in his 80s, must be feeling terribly bad. But he said the Constitution is deliberately an incomplete document. Conventions, customs, usages, all these are part of constitutional law. And if the court forgets these in its interpretation, I have no doubt it would be a flawed interpretation. Constitutional law anticipates the Constitution, which in turn brings in the concept of state to which the Constitution relates. The Constitution is the very lifebreath of a nation and the vehicle for its progress. Vehicle for its progress is a beautiful expression that Justice Hansraj Khanna used in his Keshwananda Bharati judgment. It's the country's supreme law. As Thomas Cooley, perhaps one of the oldest and most distinguished authors of constitutional law, says in his seminal work, Constitutional Limitations, a constitution is sometimes defined as the fundamental law of a state containing principles upon which government is founded, regulating the division of sovereign powers, and directing to what persons each of these powers is confided and the manner in which it's to be exercised. It's a framework of political society organized through and by law, in which law has established a permanent institution with recognized functions and powers. It sets out the framework and functions of the government and declares the principles governing the operation of those organs. Professor Anthony King, in his Hamlin Lectures at the turn of the century 2000, the title of the lectures was, Does the UK have a constitution? Says yes, even UK has, though it may not be written. He defines it as the set of the most important rules and common understandings in any given country that regulate the relations among the country's governing institutions and the relation between those institutions and the people. So the Constitution ultimately is therefore about a division, distribution, management of state power to prevent arbitrariness and establish accountability to law. The objectives of a written constitution are broadly threefold: to establish a framework of government, to assign the powers to the various organs, and to restrain the exercise of those powers in order to preserve individual rights. Constitutions provide the means to guard against the state capacity of invading liberties available and guaranteed to all civilized beings. A written constitution with a Bill of Rights does not have only the concept of the rule of law. Rule of law, as we all know, is a concept from Britain. Of course, we had it in our own scriptures earlier. They're beautiful, I think, one of those stories of the kings of Kashmir. You have the beautiful concept of the rule of law. But coming to more modern times, the concept of rule of law is from Britain, that every executive action must have the backing, the support of law. But in a country with written constitutions, we have not only the rule of law, but what is called the reign of law, the absolute reign of law, where even legislative functions, legislative enactments, the laws made by the legislature are subject to constitutional values and constitutional limitations. A written constitution with a Bill of Rights seeks to place certain human rights and fundamental freedoms beyond the reach of ordinary laws, because these rights do not depend upon the whims of an immoral majority or the outcome of any election. And that is particularly so as regards the right to life and liberty, which is perhaps the highest in the scale of constitutional values. They are not the gift of any law or the constitution. In fact, this was the cardinal mistake in ADM Jabalpur, where the majority thought that Article 21 gave us the right to life and liberty. Article 21 only prevents the deprivation of life and liberty except by process of law. It's only Justice Khanna who recognized that the right to life and liberty inheres in us as human beings. As Professor Edward Corwin said, these rights owe nothing to their recognition in the Constitution. Such recognition was necessary if the Constitution was to be regarded as complete. The debt of constitutional concepts to natural law cannot be overlooked. In fact, Thomas Jefferson, writing to James Madison in 1787, said, "A Bill of Rights is what people are entitled to against every government on earth." A constitutional state is one in which the powers of government, the rights of the governed, and the relations between them are adjusted. Every state has some kind of a constitution. The Soviet Union also has a constitution. Communist Russia also has a constitution. India also has a constitution. Ireland, United States. But then there is a marked difference. The term constitutional government is applied only to those governments whose fundamental rules or maxims locate the sovereign power in individuals or bodies designated or chosen in a prescribed manner and define the limits for the exercise of those powers and shield them against arbitrary exercise. And of all forms of government, a democratic government with a Bill of Rights comes closest to the attainment of these ideals. All states with some constitution or the other purport to govern for the welfare of the state. But as I said, what distinguishes a democratic state from a totalitarian one is that free democratic societies respect basic rights and endeavor to achieve their objectives through the discipline of fundamental freedoms. No progress and development at the cost of basic freedoms, however attractive they may seem for the passing moment. The creation of constitutional government, says Raymond Molley, this is one of those that Palkiwala always referred to. Raymond Molley said it's the most significant mark of distrust of human beings in human nature. It signalizes a profound conviction, born of experience, that human beings vested with authority must be restrained by something more potent than their own discretion. So that's the basis and the need for constitutional government. I would briefly refer to classifications of the constitutions. They are classified from different standpoints. The first, and perhaps what is known to everyone, is the written and the unwritten constitution. In an unwritten constitution, the fundamental rules and principles are scattered over many documents, charters. In fact, for Britain, you begin from the Magna Carta. While in a written constitution, these fundamental principles are embodied in one document. But we must also remember that every written constitution is also modified through different means. It doesn't remain the same thing. It's not a fossil. So the difference is really one of degree rather than kind. And the most important features of a written constitution that distinguish it from an unwritten one is that it's formally enacted at a particular time. It's called a work of conscious art rather than a product of historical evolution. Written constitutions are generally drawn by a constituent body and contained in a single instrument. Its special sanctity is that it cannot be changed by ordinary process of legislation. A written constitution involves division of powers and prescribes a limited government. The following are the important incidents of a written constitution as a legal instrument. It is justiciable, enforceable in a court of law, like any other legal instrument, and is capable of being interpreted by courts like a statute. It is a statute, of course, though a fundamental statute. It's capable of being changed by a formal process. The Constitution constitutes the higher law and therefore acts as a limitation upon all organs of government which derive their powers from the Constitution. That's why it's picturesquely said, all are creatures of the Constitution. All the three wings are creatures of the Constitution. The Constitution alone is supreme. All talk of either judicial supremacy or parliamentary sovereignty is all absolutely misconceived. The concept of higher law leads to the concept of judicial review, which is an incident of and flows from the idea of a fundamental law of the Constitution as the touchstone of the limits of powers of every organ of the state. The judiciary being the interpreter and of the Constitution and therefore of the limits of the powers of the various organs. This imports the idea of ultra vires in constitutional law. When you say it's unconstitutional, essentially it's ultra vires. The judiciary is the guardian of the Constitution, particularly of a federal constitution, with the power to declare as unconstitutional any law or action of any organ of the state which transgresses the higher law. Constitutions are then classified as flexible and rigid. And of course, the common test is if it's amendable more easily, it is flexible. If it is difficult to amend, it is rigid. In fact, this classification was expounded by Lord Bryce in his History of Jurisprudence. Another classification is unitary and federal, because we are all federal. In a unitary constitution, the legislature of the whole country is the supreme lawmaking body. The other legislative bodies, if at all they are there, are all subordinate. Constitutions which are federal are also supreme and rigid in the original sense in which Bryce used that term. It is of significance to note that a constitution is supreme means to describe its relation to the legislature of the country, and the legislature's power to alter the constitution is either limited or non-existent. Then, of course, there is the significant classification of a constitution establishing either a parliamentary system or a presidential system. That is based on the method by which powers are distributed between the various organs, the doctrine of separation of powers, which is more pronounced in a presidential system. In a parliamentary system, indeed, there is fusion of powers, at least between the legislature and the executive. Separation of powers is for the judiciary and the other two wings. Because laws, no doubt, are made by the legislature, but they are always conceived, introduced, piloted by the executive. As you all know, a bill first takes its origin only in the cabinet. It's the cabinet that proposes a bill, the cabinet that drafts the bill, and then presents it to the House. So that in that sense, there is greater fusion in a parliamentary system between the legislature and the executive. And that's why in the famous Ram Javaya case, Chief Justice Bijon Mukherjee very pithily said, separation of powers in the sense that no wing exercises the powers essentially of the other wings. Not that there can be no overlap. Then, of course, there is also the classification of between republican and monarchical. In a republic, the head of state is always to be elected. What a constitution should contain, it's profitable to refer to what Chief Justice Marshall said in McCulloch versus Maryland. He said its nature requires that only its great outlines should be marked, its important objects designated, minor ingredients which compose those objects be deduced from the nature of the objects themselves. For the intention of a constitution is only to outline principles rather than engrave details. Ideally, it must contain minimal. Of course, the Indian constitution does not satisfy that criterion, and Dr. Ambedkar very rightly explained why in our context and background we needed a more comprehensive document. From a strictly legal standpoint, a constitution has legal authority because it is enacted by a body recognized to give it force. Once a constitution is enacted, even when it has been submitted to the people for approval, it binds thereafter not only the institutions it establishes, but the people themselves. They may amend the constitution, but by a method which the constitution itself provides. Constituent power, that's very important. It's the means of changing a constitution. Because ordinary legislation is lawmaking under the Constitution. Constitutional legislation is law appertaining to the Constitution and above the mass of ordinary laws. Even when the legislative and constituent powers are vested and exercised by the same body as our own parliament, the distinction is very significant and never obliterated. The importance of the amending power is brought out very beautifully by Hermann Feiner in his Theory and Practice of Modern Government. He defines the Constitution as its process of amendment, for in his view, to amend is to deconstitute and reconstitute. The amending clause is so fundamental to a constitution that he is tempted to call it the Constitution itself. Of course, the difficulty in amending makes almost impossible the surreptitious abrogation of rights guaranteed by the Constitution. Our Supreme Court, I think in the Article 370 case, Justice Chandrachud speaking for the bench, also spoke of a derived constituent power. I'm not sure what it is. What they said is derived because it originates in the Constitution, and that while no provision of a Constitution as originally framed can be ultra vires, definitely, because there is no touchstone outside the Constitution by which the validity of a constitutional provision can be tested. The power to amend cannot be equated with such power of framing. The amending power has to be within the Constitution and not outside. Maybe, but that cannot dilute the quality of the constituent power, which, whether exercised originally or in later time, is essentially a power to amend. While the political sovereign is we the people, the legal sovereign is the constituent power. And once a constitution is enacted, the legal sovereign is necessarily the power of amendment. So whether you call it derived or original, I think it makes hardly any difference. Constitutions, when they are framed and adopted, tend to reflect the dominant beliefs, political, economic, social, of the society at the time it is made. But a constitution must necessarily be susceptible of change. It cannot be frozen in time or idea. Though, of course, there are certain immutable concepts associated with the constitution. The forces that impact the constitution, bring about changes are primarily amendment, of course, the formal amendment, which we all know, judicial interpretation, equally important. You have a beautiful, which I'll just refer to, a beautiful passage by Alfred Deakin, a very distinguished Attorney General of Australia, while moving the bill in 1903 for the establishment of what is now the High Court of Australia. Judicial interpretation and decisions and usages and customs that develop and contribute to this change. Lawrence Tribe said the visible constitution floats in a vast and deep and crucially invisible ocean of ideas and experiences. And it is in the depths of that invisible ocean that the constitution finds its true meaning. Courts do not amend the constitution. They can't, but by interpretation in a series of decisions, they elaborate the content of a word or phrase. They may modify or supplement or refine previous decisions, sometimes even change them. Words are empty vessels into which judges pour content and meaning, because that's the beautiful language of learned hand. And this is what the distinguished Attorney General Alfred Deakin said. The nation lives, grows, and expands. Its circumstances change. Its needs alter. Its problems present themselves with new faces. Amendments achieve direct and sweeping changes. But the court moves by gradual, often indirect, cautious, well-considered steps that enable the past to join the future with undue collision and strife in the present. I thought very profound idea, very elegantly expressed. Coming to constitutionalism, or constitutional culture. Constitutionalism essentially is an attempt to establish the supremacy of law. Its essence is the submission of politics to law. A constitutional democracy by itself would mean nothing much. For a constitution, however noble its ideals, however lofty its extortions, is not self-executing. It needs human agency. It is what a people choose to make of it. The mere existence of a constitution by itself does not ensure constitutional culture. Constitutionalism is essentially limited government under a fundamental law. I think that's the beautiful title of the 1972 Tagore Law Lectures by Dr. Durgadas Basu. Limited government and judicial review. What is important is the political traditions of the people, their spirit and determination to work a constitution. Constitutionalism signifies that the exercise of government power should be controlled to ensure that it does not destroy the very democratic values which it is intended to promote. It sets the minimum standards of constitutional government, emphasizes institutional arrangements must provide for effective control, absolute power must be avoided by a diffusion of authority which introduces checks and balances in the system, a politically neutral civil service, an independent police force, an independent academic and practicing legal profession, an independent judiciary, a free press reflecting diverse points of view. These are essential concomitants of a constitutionalism. Do we have them? I don't know. Of course we have. I'm not saying we don't, but they seem to be waning. And therefore, it is that we, the people, must do everything within our command to ensure that these ideas do not diminish, but they are always kept on the highest pedestal. A constitutional democracy can work only under institutional safeguards. The successful working of a democracy depends not merely upon allegiance to constitutional provisions, the letter of the Constitution, but imbibing a constitutional culture, the spirit of the Constitution, which cannot be inherited in the bloodstream. In fact, this is what Nani Palkiwala time and again used to remind us, we the people. Freedom is not something to be inherited in the bloodstream. Every generation will have to fight for it, will have to cherish it, will have to nourish it. A cultivated respect for law and enduring institutions is therefore of utmost importance. It is rightly said that an unfailing index to the maturity of a democracy and cherishing and living by a constitutional culture is the degree of respect for unwritten conventions. What is unsaid in a constitution is as important and eloquent as what is expressly stated. And to repeat what I said yesterday, a constitutional equilibrium can be preserved only by obedience to the unenforceable. This idea, obedience to the unenforceable, has been beautifully captured by, I think, Professor Murray Taylor. And this is what he said. That beyond the sphere of duty, which is legally enforceable, there is a vast range of significant behavior in which the law does not and ought not to intervene. This feeling of obedience to the unenforceable is the very opposite of the attitude that what is technically possible is allowable. This power of self-discipline is the very opposite of the fatal arrogance which asserts whether in government or personal behavior, that whatever is technically possible is licit. All through history, men have needed it to preserve them from the temper which hardens the heart and perverts understanding. These are dangers that a constitutional state and its people must always bear in mind and be on their guard against. Constitutions, it is said, can be easily copied, temperaments cannot. And therefore, constitutional values and aspirations would have to be internalized in the psyche of the nation. The Constitution of India, coming to our own, is perhaps one of the finest products of human ingenuity. It represents a summit of consensus in our history. It manifests the best in our past, provides a considered response for the present, and possesses sufficient resilience to weather the demands of the future. The Constituent Assembly was composed of men of the highest caliber, drawn from different sections of society representing various shades of opinion. The deliberations were of the highest order. In fact, it has been said that when debates were on the question of fraternity, they rose to great spiritual heights, not just political heights. Acharya Kripalani, in the Constituent Assembly debate, when we were incorporating the concept of fraternity, a word found only in the preamble, nowhere else, but which I believe, and it's truly so, permeates the entire Constitution. The presence and participation of such a vast, inclusive cross-section imparted a non-partisan character to the deliberation and enhanced the authority of the Assembly. Just to give you some practical details, the Constituent Assembly, as you all know, met for the first time on the 9th of December 1946. Deliberations continued till 26 November 1949 when the Constitution was adopted. The sittings spread over 1,084 days, 2 years, 11 months, 17 days. It held 11 sessions covering 165 days, of which 114 days were devoted to the consideration of the draft constitution. The cost of this whole venture, our most precious heritage, in terms of money, how much did it cost? 63 lakhs, 96,729. That's, by today's standards, the meager cost of our constitution. Not less than 53,000 visitors were in the visitors' gallery when the constitution was considered. Our constitution is definitely drawn from many sources. It's a happy blend of many strains. Most of the provisions are based on the edifice of the 1935 Government of India Act. It does not, however, mean that the Constitution is a carbon copy of the 1935 Act. The framers also drew profusely from other constitutions, the US, Australia, Canada, Ireland, Japan, and of course, the unwritten conventions of the United Kingdom. And there's nothing wrong in borrowing. Dr. Ambedkar answered this. He said, there is nothing to be ashamed of in borrowing. It involves no plagiarism. No one holds any patent rights in the fundamental ideas of a constitution. And he went on to say, quoting Voltaire, originality is nothing but judicious imitation. The most original writers borrowed from one another. Two fundamental ideas underpin the Constitution. The value of liberty, that will and not force is the basis of government, and the value of justice, that right and not might is the basis of every political order. The largest experiment undertaken in human history in the art of democratic living has been carried on in India since 1950. I think all our problems apart, this one thing is enough for us to pat our backs. Yes, we have had problems, we still have problems, even in elections, but still, never before and nowhere else has more than 1/6 of the human race lived together in conditions of freedom as one political entity. From 1952 onwards, we have seen successive peaceful changes of government. Whatever the acrimony, whatever the mudslinging, whatever the levels to which political discourse descends and descends as it does today, yet after the election results, the change of government is absolutely smooth. It is brought about by the ballot, never the bullet. And that is something which I think all of us must feel absolutely proud of, surrounded by countries where everything but this happens. The Constitution has established a sovereign, socialist, secular, democratic republic. Each of these words has its own pregnant meaning. Democratic is comprehensive. Republic signifies the head of state is always elected. The 42nd Amendment introduced the words socialist and secure. There's a lot of, I would say, unnecessary debate now. But believe me, these words, or these ideas, these ideas were always inherent in the Constitution. What was already there was expressly stated by the 42nd Amendment. Whatever else we may have about the 42nd Amendment as being so bad, that apart. India is a secular nation. There are so many. What else is it when we say liberty of thought, expression, faith, belief, worship, freedom of religion? Socialism, yes, of course. Socialism not in an ideological sense, not in a political sense, but definitely in a pragmatic sense. What else is the directive principles of state policy? In fact, this is, if I may digress for a moment, the interpretation of the Bible on the continent of Europe and in the United States. Europe has always lived as a community. What, to put it in very simple language, perhaps the language of Mahatma Gandhi, what I have is not just my own, it is ours. In America, I live for myself, I die for myself, what I make is mine. The rest do not matter. That has not been the idea of Europe. It has never been the idea of India. And that is all what our socialism is all about. And therefore, to talk of whether we should have it, whether we should delete it, waste of precious time. And technically, this amendment has been upheld in the Minerva long, long ago in 1980. The Constitution represents a charter of power granted by liberty, not a charter of liberty granted by power. Apart from a broad framework of government that it provides, is endeavors to protect liberties and secure justice. The Constitution is not just a legal document, as Justice Bhattacharya pointed out. It's as much a social testament and a political instrument. It provides for stability without stagnation and growth without destruction of essential values. It seeks to secure the goals set out in the preamble: justice, liberty, equality, fraternity. A majority of the provisions are aimed at furthering those goals. Then the core of the commitment of the Constitution, as we all know, lies in Part 3, 4, and 4A. The Constitution has adopted a parliamentary system of government whose basic tenets are the primacy of the Prime Minister, the accountability of the government, the executive branch, to the lower house of the legislature, and collective responsibility. The constitutional position regarding the exercise of power by the president and the governor is too well settled. Forget the Supreme Court opinion. Please push it away. It's an opinion. The Constitution has set up a broad federal structure, resilient enough to adjust according to the exigencies. There's a division of powers not only among the three wings, but between the center and the states. The concept of federalism basically involves a distribution of powers between the center and the federating units. India is described, and purposely, meaningfully, not as a federation, indestructible union of states. That's how the Constitution describes it. The basic principle of federalism, as Dr. Ambedkar pointed out, is that the legislative and executive authority are partitioned between the center and the federating units by the Constitution itself. This is the basic requirement. It's not by any law made thereafter. Then various variations are permissible. That does not any the less make it any the less a federation. Of course, there is a bias in favor of the union, and that's why it's sometimes called quasi-federal. Think Justice Beg in state of Karnataka versus Union of India very picturesquely called it amphibian. And in times of emergency, it could be unitary. In other times, it could be federal. The success of a federal polity depends upon maximum cooperation and coordination between the various governments, and that's the idea of cooperative federalism, which even a strict federation like the United States, since the opinion of the Supreme Court in Carter versus Coal Company in 1936, cooperative federalism is the concept now. None of the wings enjoys any monopoly of wisdom, and in the pattern of functional distribution, there is hardly any room for supremacy. This then is our Constitution, which was described as a precious heritage by Chief Justice Chandrachud in the Minerva Mills case, and a sublime constitution by Chief Justice Maharaj. The constitutional experiments in India may be said to be a saga of statesmanship, hope, and faith. There were sublime moments. There were also times of distress and turmoil. But I believe the overall response of the Indian state to the democratic aspirations of our people and the urges of Indian nationalism has been one of satisfaction. The Supreme Court took great strides in developing constitutional law, and the theme of that is law as a check on power, public power. This is the whole idea. The various judgments only emphasize that. It is startling to imagine, I said it yesterday, I repeat it today, what would have been the position if these cases had not come up before the court and decided in the way they have been. Today, it looks to us to be in the usual course of affairs. But then these developments were brought about by great judges. Slowly, cautiously, the edifice was built brick by brick. All power, including judicial power, is a trust, and judges are trustees. Constitutional government is limited government, which is the essence of constitutionalism. One of its enemies is absolutism of any kind. As trustees of limited government, judges have protected and upheld individual rights, enforced constitutional limitations, disciplined the exercise of power, held government and authorities accountable. There are many cases, and all that I would say is these are cases in which the court promoted constitutionalism. What is constitutional? Constitutional culture is abiding by the Constitution, a limited government, that no power is unfettered or unlimited over a series of decisions. Royal power, arbitrariness is the antithesis of equality. Mohinder Singh Gill, natural justice. Maneka Gandhi, procedure established by law. Yes, procedure must be fair, reasonable, and just. Singhal, all hold office at the pleasure of the president. It's not his personal pleasure. That pleasure, the Supreme Court in Singhal's case, it tempered it with what I would call the constitutional ethos. Epuru Sudhakar, the pardon power, again, that's not something like a royal prerogative to be used. That again was tempered with constitutionalism. The power to make ordinances, yes, absolutely required, but that doesn't mean that you go on having an ordinance Raj, Vadhva's case. So there are many like this, and that's what I said. Step by step, brick by brick, the edifice has been rightly magnificently built. And that is the court's contribution to developing, upholding, and nurturing a constitutional culture. State of Tamil Nadu versus State of Punjab versus Governor of Punjab and State of Tamil Nadu versus Governor of Tamil Nadu, the Supreme Court did a great service to the Constitution and the nation. The presidential opinion on November 20 did the greatest disservice that one could imagine. Struck a death blow to democracy, constitutionalism, and federalism. The earlier it is shot down and confined to the dustbin of history, the better for this nation. Fortunately, it's only an advisory opinion and so worth nothing. It is not 141 law. But still, it is unfortunate that the highest court, the guardian of our constitution, defaces, desecrates, defiles the constitution. Sorry, I know I'm speaking to judges, but you're essentially citizens. Palkiwala spoke of our constitution being defaced and defiled by unconstitutional amendments to the constitution by parliament. Unfortunately, that blame does not lie only at the door of the legislature. It's equally shared by the judiciary, which is supposed to be the guardian of the constitution. I am sorry to say this, but I'll be failing in my duty if I remain silent. We now refer to cases like Jogendra Kumar, D.K. Basu, prison reforms, Jolly George versus Bank of Cochin, Krishna Iyer's judgment. A debtor cannot be imprisoned only because of his inability to pay the debts. This is a case which I think is both an example of judges acting as trustees of limited government as well as judges acting as trustees of enlarged government. Jolly George is what Krishna Iyer only carried forward in the Supreme Court what in 1968 or 69 he had done in the Kerala High Court. He first did it there. 1980 it came in the Supreme Court. The constituent power itself has been held to be limited. Keshwananda Bharati, I don't have to talk more on that. The idea was reiterated in the Prime Minister's election case and Minerva Mills case. But the essential idea of the basic structure is this, that by a process of amendment, the Constitution should not be denuded of its core or made to suffer a loss of identity. It's a Constitution it framed, adopts some ideas, but then they cannot be frozen. And therefore, a constitution must be capable of change and amendment. Judicial review and legal control is the auxiliary precaution. The primary precaution is the electorate, but then it has its own limitations, and therefore the need for an auxiliary precaution that James Madison spoke of in The Federalist. And judicial review and legal control of government is that auxiliary precaution. Now, constitutional values, constitutional values are reflected in the preamble: justice, liberty, equality, fraternity, assuring the dignity of the individual and the unity and integrity of the nation. So also the principles of democracy, republicanism, secularism, socialism. Now, an awareness of these constitutional ideas and adherence to these constitutional values is absolutely relevant and essential for justice delivery at all levels. Constitutional courts, yes, Supreme Court and the High Court are constitutional courts, but the other courts, subordinate is not an expression used because the other courts are subordinate. It's just an expression that the Constitution uses to identify the other courts, nothing subordinate. The other courts as much the creation of the Constitution and have to work in sync with the Constitution, its values, its principles, its aspirations, its values, its limitations. Constitution speaks of justice, and justice is what courts are meant to deliver. And justice is the first word in the preamble. Justice and then others. Justice, equality, justice, liberty, equality, fraternity. The essence of justice is the attainment of common good. Equality of opportunity is the soul of social equality, and social justice is perhaps the most important foundation on which a society can survive. Liberty, of course, is what is the yearning in every human heart. And it's only under circumstances of liberty that you can have the efflorescence of the human personality. Nothing great in art, culture ever comes about when the mind is shackled. It's only in circumstances of freedom and liberty that we grow. So to equality. Of course, equality again is not wooden equality, and that's why affirmative action, reservation, etc., to bring about a more meaningful equality. But ultimately, fraternity is the final objective in the preamble. And fraternity, said Dr. Ambedkar, means a sense of common brotherhood of all Indians. It is that spirit of brotherhood which the preamble refers to. An awareness and adherence to these principles is absolutely essential. Even the Universal Declaration of Human Rights in Article 1 speaks of this idea: all human beings are born free and equal in dignity and rights. They are endowed with reason and conscience and should act towards one another in a spirit of brotherhood. So again, you have the concept of fraternity. Fraternity was added to the preamble because it was felt that the need for fraternal concord and goodwill was never greater than now. It is even more essential today, 75 years later. There's a beautiful passage from Professor Ernst Barker, a political scientist. He says that justice is the synthesis of liberty, equality, and fraternity. It's this thread that runs through all these values and makes them part of an integrated whole. It reconciles conflicts and contradictions. It's the basic idea behind liberty, equality, and fraternity. It's the final goal to which these should conform. He describes the relationship between liberty and equality as justice joining or fitting together, not only of persons, but of principles. The transcending final principle which can balance each of these against the others is justice. And justice is what all of you are called upon to administer and dispense. And in dispensing justice, the subordinate judiciary, pardon me, I mean nothing subordinate, I'm only using the term that the Constitution has used, cannot be blind or indifferent to constitutional provisions. They have to keep them in view while deciding cases. Many principles come into play. I'll just refer to one or two. Article 21. I think the top of the pyramid. All other rights fade in comparison with that, because it's only if I'm alive that I can have any right. So the right to life and personal liberty stands at the summit. And this becomes very relevant in cases of arrest and bail, Article 22. And that's why yesterday I said that the Supreme Court under 32 and the High Courts under 226, when it's a writ for enforcement of fundamental rights, there is absolutely no discretion. If judges think it is discretion, it is abdication of the judicial function. You may have any other docket. It's immaterial. Please recall the first page of the first Hamlin Lectures by Lord Denning in 1949, Freedom Under the Law. And this is what he says, and that's equally true for us also. When a king's judge takes his seat and counsel says, "My lord, I have a petition for habeas corpus," the judge sets aside all his work and takes it up. That is his primary responsibility. In India, that is so. In England, by tradition. In India, it is so by a constitutional command. The Supreme Court is constituted the protector of fundamental rights, Article 32, the heart and soul of the Constitution. The high courts are no less. And Justice Sarkar, in one of his judgments in the 1960s, I forget, said what exactly I have said, that there is no discretion, it is obligation. It is obligatory. In a suit for declaration, when a person's fundamental right has been violated, the trial court also can grant appropriate reliefs like injunction, prohibition, specific relief act. The right to life and liberty, as I said, is the most sacrosanct. The history of liberty is, after all, the history of observance of procedural safeguards. And the right to personal liberty in the common law tradition is an immunity. Whatever is not prescribed by law is permissible. I don't have to show that I can do this. You will have to show that I can't do it. The right to be left alone is the most comprehensive and valuable of all rights. It symbolizes the concern of the law for upholding the dignity of the individual. Representative suits are like PILs. Order 1, Rule 8, Section 91, Section 92 CPC, Section 133 CRPC, whatever its new avatar, I don't know. The lower courts also can grant appropriate relief to redress wrong. Again, Justice Krishnaya, Ratlam municipality case. Section 133 CRPC, how it was triggered, and what a beautiful judgment. Beautiful both for its content and its delivery. Procedural rules infuse life into substantive rights, which activate them and make them effective. This is one of the judgments that I would like to place before you. State of UP versus Maharaja Dharmendra Singh. This is Justice Venkatacharya's judgment, the Supreme. It's what I would think is case concerning private law, property law, and the nuances of public law. The interface between them, and this is what even in the lower courts you would have occasion. A lessor with the best of title cannot resume possession extrajudicially by use of force, even after the expiry of the lease. And when the lessor is a state, there is the additional inhibition stemming from the requirement that all actions of government and its authority should have a legal pedigree. Well, this is part of the concept of rule of law, that no claim to a right to dispossess by force without recourse to procedure in accordance with law is recognized by courts. The primary concept is that everything must be according to law. Another aspect is that, and it's an incident flowing from public law, the secondary meaning of the rule of law, which requires that government should be conducted within the framework of recognized rules and principles which restrict discretionary power. While manifold functions of government cannot be carried on without a good deal of discretion, all governmental power must be shown to have strictly legal pedigree. The court extends protection not of possession, but protection against forcible dispossession. So the injunction is not that his possession is protected, but forcible dispossession cannot be countenanced. It would be, if I may respectfully tell you, profitable to read Justice Venkatacharya's similar judgment in the High Court, Patil Exhibitors versus Corporation of the City of Bangalore, which was absolutely not a case in public law, which was a case not on the rich side, purely civil matter, a miscellaneous first appeal against the rejection of an application for temporary injunction, restraining the lessor from interfering with the lessee's possession. And this was the law laid down. Section 151 recognizes the inherent powers of the court. Please, it recognizes, it does not confer. The very fact it is inherent is embedded in the court. It's a cardinal principle of common law that what is not prohibited is permissible. The court has inherent power to make an order essential in the interest of justice, provided the decision is based on sound principles and not in conflict with any provision of law. We have such classic judgments on this, expounding this principle, and two classic judgments of two of our greatest judges of all time. Narsingh Das versus Mangal Dubey, Justice Syed Mahmood, 1882 ILR, the Allahabad High Court. And this very court, Sarashutosh Mukherjee, in Gurdev Singh versus Chandrika Singh, 1909 ILR 38, Calcutta, where he said very beautifully, the provisions of the code apply only in so far as it goes. The provisions of the code apply only in so far as it goes. This is the language of Sarashutosh. Inherent power is the foundation on which the edifice of the common law is built, and inherent powers can be invoked, should be invoked and exercised to prevent the abuse of the process of law and deliver justice, which is indeed protecting the rule of law and a constitutional fundamental. There is only one other aspect which I would like to refer to you before I close. I'm speaking to judges at all levels. Justice Shampa Sarkar was, yes. We did discuss it in Bhopal last month. Binding nature of the Supreme Court decisions, of course, no doubt about that. Article 141, law declared by the Supreme Court is the law of the land, binding on all. Absolutely no trouble. It is as it should be. Does this mean, however, that you give up independence of thought? Judicial discipline and the regimen of Article 141 require every judge at every level to follow the law laid down by the Supreme Court. I would not dare, not a whisper against that. That is judicial duty. It's imperative in a hierarchical system of courts like ours that the last word should belong to someone, and that having been said, it should be faithfully accepted and followed, even if anyone has any reservations about it. Yes, however, nothing prevents a judge at any level, including the lowest level, while abiding by the law laid down by the High Court or the Supreme Courts, to state in his judgment, of course, in very polite and respectful language, if he has any reservations or doubts about a view expressed by the Superior Court, and point out what he feels to be erroneous and what may be a more tenable view. Of course, he has to follow the law laid down. There's no trouble about that. You can't change the law, but you can always observe in your judgment that this is what I respectfully think is the problem. That is judicial independence and even more adherence to your judicial oath and conscience. Now, what is the principle of multiple judgments? What is the principle of a dissenting judgment? When a judge takes his oath to deliver justice, it is not to sign on the dotted line. That is essentially why multiple judgments are so beautiful. The law grows. That will give the necessary impetus for a healthy development of law and correction, perhaps at a future date. In Broom versus Castle, Lord Denning, sitting in the Court of Appeal, pointed out the difficulties presented by the House of Lords' decision in Rooks versus Barnard, and doubted the validity of the doctrine propounded by the House of Lords. In appeal, Castle versus Broom, the Lords came down upon him like a ton of bricks. Doesn't matter. But the House did consider the problem. The appeal was dismissed, affirming Lord Denning's view in the Court of Appeal. To that extent, the cause was served. We have this nearer home. You may take down the citation or I'll give you later. We have it nearer home in India. Niranjan Swain versus State of Orissa, 1989 Orissa. We had Justice Radhacharan Patnaik, R.C. Patnaik, who from the Orissa High Court, went to the Supreme Court, where he sat only for a couple of months. In a tragic road accident, when he was driving the car crashed and he died. Justice R.C. Patnaik, sitting in the Orissa High Court, this is a case in point. He respectfully pointed out the law laid down by the Supreme Court in two decisions appeared to be flawed. He stated, and this is I quote, "The rule laid down in those cases is binding on me, of course. However, with great respect, I hope the Supreme Court would, on an appropriate occasion, reconsider the views." That happened many years after his death, about 3 decades later. The court in State of Constitution Bench in State of Jharkhand versus Hindustan Construction Company did not refer to Justice Patnaik's observation, but did reconsider and change the law. The cost was served. So these are some ideas and thoughts which I thought I will very respectfully place before you. A judge ought to be sensitive to the weight of his office, the constraints it possesses, it imposes. He should be self-critical and open-minded without any arrogance. It has been rightly remarked that judges tend the gate between order and anarchy. To the extent judges can dispense justice, articulate reasons why the decisions are just, they remove from persons otherwise disaffected the feeling of injustice. They preserve our system of ordered liberties. That is one of the constitutional fundamentals. The role and contribution of the Indian judiciary in realizing the constitutional vision and promoting constitutionalism has been remarkable. The judgment of the Indian people would be that their constitutional rights are safe in the hands of the judiciary. At the end of the day, whatever the ups and downs, whatever the criticisms, and many of them are justified, but all that said and done, what was said of the American Supreme Court by Chief Justice Hughes, I think at the foundation stone laying ceremony of the present Supreme Court building, he said, "The Republic endures, and this, the Supreme Court is the symbol of our faith." I think that is all said and done, that is equally true of our judiciary and the Supreme Court. The Constitution, my dear friends, matter. It protects our lives and liberties. It ensures justice. It maintains the rule of law. Above all, it holds us together as a people and a nation. I don't think we were one people and one nation before the Constitution. The Constitution speaks through words and even silences, which are sometimes eloquent. We must listen honestly, respond responsibly. It is when speech and silence are juxtaposed that we hear a fleeting message, which is the melody of the Constitution. Thank you so much for your patience and care.
Thank you, sir. I now have the honor to respectfully invite Honorable Justice Shampa Sarkar, Judge High Court at Calcutta, to kindly grace the valedictory session with her address and formally bring the workshop to a close. My Lord.
We have come to the end of the session, and thank you, Mr. Pai, for taking us through this journey. My esteemed colleagues, the senior judicial officers, members of the registry, the batch on probation, which is going through has just about is going to begin the constitutional journey and the constitutional by adopting the constitutional culture. I start this valedictory speech with borrowing a quotation from Mr. Pai in one of his books. He says that the mere existence of a constitution does not by itself ensure constitutionalism or constitutional culture. A paper constitution is only the husk of constitutionalism. Mr. Pai has touched on the kinds of the constitution. We have a written constitution. Mr. Pai has said, judges have quoted that the constitution is precious and it is sublime. Let us begin with the preamble. It declares India to be a sovereign, socialist, secular, democratic republic. Mr. Pai has elaborated on the meaning of each of these words, not only the letter, but the spirit behind each of to secure justice, equality, liberty, and promote fraternity, which is the brotherhood. Here, brotherhood means sisterhood also. And this is how we are together. The Constitution binds us and brings us together as a family. We are to promote the dignity of an individual. Now, if we see how the preamble goes, that is the basic structure. We, the people of India, and the preamble, whatever our philosophies are, adopt, enact, and give to ourselves this constitution. So, this is the constitution we give to ourselves, which Mr. Pai has said that the citizens of the country are torchbearers. So, apart from being a people from the judicial fraternity, we cannot forget that we have an obligation towards the constitution and the laws as citizens of India. Now, the assertion of public sovereignty, the people are fundamental and they are supreme. So, this is the ethos of constitutionalism. The government is limited in its power. It derives power from the constitution which the people have given to themselves, and its power, exercise of power is restricted to the constitution itself, and it is to be implemented through the directive policies, which are the policies of the state to secure social and economic justice. So this is how the constitution principle of constitutionalism is embedded in our directive, in our preamble. We have a transformative constitution that has been highlighted in the decision of Navjit Singh Johar, where the court is the agency to bring about that societal change by interpreting a constitution which is ever evolving and dynamic. The basic features, the fundamental rights, judicial principle, directive principles, we are that has been discussed in great detail. Justice Bhattacharya says we have a dynamic constitution, which means our constitution can be amended. And multiple amendments, it often faces criticism, but the whole idea of multiple amendments is that the constitution is not rendered just a static book, a dead letter, but it can be changed to bring about a societal change for the development of the nation and the growth of the people, with the keeping in sync with the requirements of modern time. Now, the High Court's power, Supreme Court's power, High Court's power, that has been elaborated. Mr. Pai has elaborated on various judgments where legislative action has been struck down, laws have been declared to be unconstitutional, interpretations have been given to each expression, liberty, equality, etc. Of course, it is a myth that constitution is only for the High Court and the Supreme Court. The district judiciary does not exist in the vacuum. Articles 233 to 237 of the Constitution of India talks about the district judiciary, appointment of district judges, appointment of judges other than district judges, etc. The Constitution provides for separation of powers, legislature, executive, and the judiciary. Article 50 of the directive principles also provides for separation of power, which means the junior most judge, a magistrate, has the power to follow the constitution and interpret the law, to pass orders irrespective of a senior official having any kind of influence in the entire system of the administration. That is the power that we have. That is where the role of the district judiciary comes in. Because as Justice Krishna Iyer had opined in one of his judgments, that hardly anybody comes to the Supreme Court, few go to the High Court, and the most of the people go to the district judiciary. So you are the first face of the judiciary. How are we interpreting? How is the district judiciary is actually living through the constitutional culture? When you, Article 21, Mr. Pai has already pointed out, right, you are ensuring liberty. When you take up bail applications, you balance the liberty of a person guaranteed under Article 21 with the right of detention of the person. When you are taking up a criminal trial, or when an accused is arrested, a suspect is arrested, we have to ensure that they are made known the charges against them, the arrest memo is given to them, they have a right of representation. Even at the stage of interrogation, they have a right to have an access to a legal counsel. They have access to uh, health facilities. And then when the trial is on, we talk about witness protection, victim protection. All these emanate from Article 21, Article 22, Article 20, which protects accused against self-incrimination. So in throughout a criminal trial, from the stage of detention of a person, we are actually upholding, the district judiciary is upholding the constitution and living the constitutional culture. Now, let us talk about the other provisions. Right of speedy trial is also one of the right, and right to easy access to justice. While interpreting a local law, again, you are using the constitution. In partition suits or many suits of injunction, there is an injunction on the entire property. Somebody is living there, he comes with an application for repair of the house because it is in a dilapidated condition. Suit is going on for 10 years. You allow the repair by considering what? Whether the man is living, the house is in a habitable condition or is in such a condition that the roof is leaking and he will not be able to survive through the monsoon. This is what you are balancing, the dignity of the individual and the living conditions of the individual. When you talk about a transfer of a case, Section 24, the Code of Civil Procedure, district judges deal with it. When a person comes and says, I feel I will not get justice in that court, or I am obstructed to attend the court because the other side is influential and I fear I will be assaulted. So we are giving that the person, when we transfer the case, when we do so, what are we actually doing? We are trying to understand, giving him what is his actual problem, and we try to uphold his right to equal participation in a legal process. When you take up a matter, matrimonial matter, Section 24, maintenance pendentility, what are you actually balancing? Income of the husband, right of the wife to live a dignified life, commensurating with the status she was enjoying and her husband is living in. What I may need may not be what you may need. But the comparison is she should be able to live and enjoy the same status as her husband or what she was enjoying in a matrimonial home. You may feel it is adequate, but it may not be adequate for somebody else. So you are balancing that. When you are following precedents, that is also a constitutional mandate. Now let us talk about Article 39A, which talks about free legal aid. The district judiciary, through the respective district DLSAs, actually are supposed to ensure that the victim compensations, other kind of compensations available to the victims of many laws under the POCSO Act and any offense, violation against women, acid victims, all these persons, they get their adequate share of compensation that the DLSs are supposed to ensure. Right of inmates in prisons. The Prisons Act provides certain rights. We do not call the prisons anymore. It is not an institution of confinement. It is an institution of reformation. We want to bring them back to rehabilitate them, try to give them a fresh start. So this is again in consonance with the constitutionalism and the constitutional culture which is embedded in our constitution. All these laws, the Prevention of Child Marriage Act, the Dowry Prohibition Act, Prevention of Child Labor Act, these are all based on the principles of Article 15, Article 39E and F, the Dowry Prohibition Act. See, Article 51 E provides that any law or any custom which is derogatory to the dignity of a woman should be renounced. Then that is where these laws have come in. We have done away with a lot of customs which were considered to be derogatory to women, and we have brought in laws to protect them. So every kind of matter you are adjudicating, you are actually following the constitutional principles and living through the constitutional culture. Having said that, I would like to, the Juvenile Justice Act, that is another very important legal piece of legislation where the children's rights are protected. They are entitled to be tried in a child-friendly court. Bail is the rule. The identity is not disclosed. The provision of diversion is being introduced, wherein if a child commits an offense, do not bring him to the police station, do not send him to the home, do not send him to the GGB. Try at the first instance if you can just divert him to some other kind of community activity or something, so that he's away from this mainstream of trial. So these are all protections of the child, which also comes within the ambit of the Constitution. Lack of arbitrariness in state action, we are supposed to, that again, in the trial courts, you will see if the police brings in an accused, mistreats an accused, the presiding judge has a right to question, to protect, pass orders so that the accused is treated properly. So these are the aspects where these district court have a very important role to play, because they are actually living through the Constitution every day when they sit in the chair and insist on a fair procedure, and they insist on protection of the weak and the vulnerable. With these reflections, I extend my gratitude to Mr. Pai, our chairman, Justice Orijit Banerjee, who is in Andaman, our Chief Justice, who has conceptualized this program today, although he cannot be here, his lordship is in a conference, Justice Bhattacharya, Justice Joy Sengupta, Justice Tirthankar Ghosh, Justice Mantha, Justice Rai, Justice Chondo, Justice Bhattacharya, Justice Ghosh, Shubhra Ghosh, Justice Smita Das De, all the members of the registry, the director, additional director, administrative officer of the Judicial Academy, the support staff of the Judicial Academy, all the persons involved with the live broadcast of this program, all the judicial officers, dignitaries, and the batch of 2022. I hope you feel inspired after today's session. Thank you very much. Have a good day.
Thank you, Ladyship, for this enlightening address, beautifully described in the perspective of the district judiciary. May I now request the honorable judges and the dignitaries and the participants to please rise for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे